Know where you stand and your role is on the project, and that's going to determine what type of insurance, not only that you may be required to have. If you're a general contractor, the owner may tell you what you have to have, but go to your insurance professional to ask, what do I need? Not just what does the contract require, but what do I need? The next step is certainly know the difference between insurance and suretyship. Know when bonds are required or not required. Know what type of insurance is required, and you know that by reading your contract. So you have to, if you're an attorney or insurance professional and your client is trying to defer to you solely on what insurance to get, first, if you're an attorney, say, I need to defer the insurance professional, but here's my position, my advice. If you're the insurance professional, you need to have a conversation and you need to look at the contract to see what's required. And again, defer to your client, though. Look, this is my advice, but you're the ultimate decision maker as well. Read your policy and bond. We see this so often where a policy is requested and the agent doesn't confirm that requested additional insured status was added. The insurance company never agreed to provide it. The form wasn't filled out completely. Project happens, issue occurs, lawsuits filed, and there's no additional insured coverage at the end of the day. So
that, just like John's saying is, back to the know where you stand. This is why it's important to read your contract and read your policy. If you're performing certain kinds of work, that might not be standard coverage. You might need to know that you need something a little bit more. Maybe you need environmental coverage that isn't going to be standard in your CGL policy, but you need to know to ask the question. So,
and as we said, you have to know the law in the state when you're drafting contracts to make sure they're valid, particularly indemnity and insurance provisions, and know the law in your state. If you have a Public Works Act, you need to know what the requirements are for filing claims under a bond. It may be that a lot of language in that bond is actually stricken, and you have to strictly follow what the statute says, not what the bond says. So that can get you in a difficult situation if you don't know that. And then regarding timing of claims and current occurrence versus manifestation, generally all insurance policies and all surety policies or bonds rather require notice within a particular time or within a reasonable time or within a year, or within a month, whatever it is, know what that requirement is. And that just goes back to knowing the law and reading your contract, which would include the bond or policy. So
don't sleep on it.
Exactly. So thank you for coming here today.